Ms. Stinson is the person responsible for this tragedy. This is a legal process, not only a social services process. We welcome the feedback of the independent review of the system of care by the Department of Children and Families, and will implement every strategy necessary to continue to protect and serve our children. Case managers do not have the legal authority to remove a child or children from their caregivers. That responsibility lies with the child protective investigators. I'll turn it back over to Chris.
No. I think we're open for questions now. If somebody, yes, sir.
Yeah, I wanted to raise a question concerning the custody of Jordan Belliveau. There's been reports that that as early as a day before he disappeared, that there was a warning to his family that he was possibly going to be removed. Was that true? That your agencies were trying to threaten to remove him a day before he had disappeared?
I don't know that there was a threat. There certainly was a discussion with mother that if Ms. Stinson, that if she, did not increase her participation in the activities that had been set forth by the court, that there would be the potential of a removal of her child. That's pretty standard dialogue during a home visit for parents who have been reunified and who have tasks that they need to complete.
How long before that statement was made to her? What is the process that would happen after that could carry out that statement?
The case manager and any other child welfare professional who was working with the family would have the opportunity to bring that to the attention of the child protective investigator assigned to the case. There is still an open case. There was an open case at the time. So it would have been reported to the child protective investigator and or if they're, and or calling another abuse report into the hotline.
What evidence had Ms. Stinson showed from the time, really from the beginning of 2018 until the child was put back in her home, what evidence had she showed that the problems in that home and with her and her boyfriend, what had she shown that she improved in any of those areas?
Ms. Stinson, the reason for removal was environmental hazards, and certainly from the time frame that you're referring to from 2018, she had secured independent housing that was free of those environmental hazards. She had secured employment, and she was cooperating in completing her therapy sessions.
If I may, one of your caseworkers, and this is in the documents released today, said essentially that all of those things fell apart almost as soon as the child was put back into the home. And she asked Ms. Stinson that, and Ms. Stinson got upset and began, I think it said, crying, although I don't remember the exact verbiage used. So how could it have been so fragile that things fell apart almost as soon as the child was put back into the home?
We are going to wait for the independent review to identify that. I can't really speak to, your statement that almost immediately that it began to fall apart. I need to wait.
That's what the caseworker said. Do you agree with that's what the caseworker said?
I don't know if the caseworker said that.
Ms. Lott, the night before this child's murder, your caseworker visited the mother. At that point, he knew that in July there had been physical violence between the mother and the father. He knew that in August, the mother wouldn't open her door to child abuse investigators and had to take a police bullhorn to get her to open the door and cooperate. Later, the week before, also knew that the guardian ad litem was refused access to the child, knew that the mother was being evicted, knew that the mother was pregnant, knew that things were being repossessed from the house. Her entire life, and more importantly, the bargain that she made with the court, the contract she made with the court, she wasn't holding up. So when you add up all of those things, why didn't your caseworker, either that night or on all those previous occasions, take any action to initiate the action of taking the child out of harm's way?
The caseworker did not assess impending danger. The caseworker was, in fact, as you've indicated, in the home on the 31st, on Friday, spent a significant amount of time with mom, and the case manager did what case managers do, which is they assess and identify barriers and begin to manage around those and put into place how we can solve and resolve the barriers. And in fact, that is what he did. I will say that the case manager also, after, had conducted a 911 check post reunification, and that is when we were informed that a domestic violence call had been made. The case manager did call that into the hotline. The case manager did cooperate with child protective investigators during that process. The case manager did update the case plan to include that fact and to identify additional tasks. So I think to suggest that the case manager didn't do anything is a mischaracterization. The case manager did what that case manager believed to be right and in the best interest of that
But
child.
if I could follow up, when you say the 911 call, that was triggered by what? The abuse call was triggered by which event?
As a part of the case plan, one of the strategies that we used and use often is to, on a routinely basis, on a monthly basis, to pull 911 checks to see if there's been any 911 calls to a home. We did that as a part of our case plan, and when we did that, that is when we were notified of that domestic violence incident that took place in July.
And then we called a hotline, and the hotline investigator came out and did their investigation.
But in that situation, again, when there was a visit by the CPI investigator, it took Largo police with a bullhorn and an hour and a half or 2 hours of negotiation for this woman to even open the door. Wasn't that, in and of itself, reason to think this child was in danger? It was a virtual standoff.
That would be a question for Largo Police Department.
Not
But
Largo,
it's a question for your caseworker who was managing the case. He knew about it.
but it would be, that's a protective investigation decision, and the protective investigator had declared that there weren't sufficient grounds to remove. Our case manager is, the only thing they would do is call that investigator back again and say, what do you think? And they've already said, we don't have grounds. So that's, I mean, we're not trying to excuse this, we're not trying to make light of it, but there was that event and that investigation, and that took place, and they did not find grounds.
How many times was Jordan removed from the home in his 2 years of life?
Once.
Just once. Was that in May? We also hear that in November 4th of 2016 that he was removed, that he was reunified in May of this year. So he'd
Right.
been out of his mother's care for that length of time.
Yeah.
And could you explain to us, we're trying to understand, what was it that made the magistrate decide that it was safe for him to return home in May, and then 3 months later he ended up being dead?
There were identified conditions for return, and those conditions for return had been met.
What were those conditions?
One of the conditions was that the mother and or parents had a safe environment that was free of environmental hazards, which was the original reason the child came into care, that the parent had stable employment, that the parent could demonstrate the maturity level to take care of her child, that the mother would understand the relationship between, being exposed to gun violence and or gang violence would be harmful to the child.
And it's important to note that the parents were represented by legal counsel who are advocating in that courtroom for the rights of the parents.
There was also in that court was guardian ad litem who
Yes.
was advocating for the child. And they had said that they did not recommend that he be put back into their care. How much weight does their opinion carry in this?
Again, I believe that question is probably for someone other than us. I will say.
Well, they serve under you, though.
No.
No, they do not. They do
Guardian
not.
ad litem
They-
is
They're a
a,
volunteer group, I understand.
They're a
but-
separate and independent organization from either one of us.
But does Eckerd Connects or Directions for Living give an opinion to the court on whether someone should be returned to, a child should be returned to a parent?
Yes.
Did
What
you
was
give
your
that opinion?
recommendation on that day?
Our recommendation on that day was to move forward towards reunification. On the particular day that you're referring to, there was an objection by all parties based on the fact that there was not supporting documentation in the record to support Ms. Stinson's claim to have completed her counseling. So there was an objection by all parties, including the guardian ad litem and the case manager, referencing those documents.
One of the fundamental requirements in that court order, which returned the child to the parents, is that the mother should have stable housing and income. Your caseworker knew for months she didn't have either. She was being evicted, she was jobless, she had no furniture, it was being repossessed, there was domestic violence, she wasn't cooperating with your caseworker, other investigators, the guardian ad litem. How does any of that not add up to danger for that child?
The issue around stable housing is, one that we face routinely. Many of our parents get into housing, maintain housing for months, and then housing becomes unstable again. Permanent housing, affordable housing in Pinellas County is difficult, and the fact that she was behind in her rent had been identified. And we were working in partnership with her to either pay the back rent and stabilize her as she went on job interviews and continued to seek and gain meaningful employment.
But again, it wasn't just the fact that she was going to be evicted. She didn't have a job. She was going to be evicted. There had been domestic violence. She was refusing to cooperate with anybody involved in the case. How could all of that be ignored and not brought to the attention of the court? Why wasn't this brought to the attention of the court?
so one thing I would add to that is that we work with these families all the time in housing and employment. And she knew that we would secure housing for her. She had identified a couple of places that she thought would be good for her and affordable, and also with employment. We work with these families all the time in these arenas. Remember, the issues that initiated this case were not that mom was abusive towards her child. It was that she was living in a dangerous place. And we were committed to helping her stay out of that dangerous place.
I have a couple of questions about this domestic violence incident that happened on July 14th. Charges are filed by deputies on the 15th. The final order, and I understand the hearing had happened before that, but the final order was signed by a judge on the 16th. So you've got the incident, the charges being filed, and then the final approval given on the 16th. 3 successive days, literally, one after the other. How is it possible that a judge is able to stamp a document when the day before there was a physical altercation over this child? Is there no safeguard in place? And how do you explain to all the people with children in the system that that could have happened?
The safeguard that is in place is that when the responding law enforcement agency responds to a domestic violence call, they are a mandated reporter, just like most of us, probably in this room. If they assess danger to that child as a result of that domestic violence incident, they are mandated reporters to call that in. I can't speak for the responding law enforcement agency in this instance. If they had assessed present danger, if they had assessed that child was in peril, they would have called that into the hotline. Had that happened, we would have brought that immediately to the attention of the court.
I just want to be clear. So you're saying that either of your group, neither of your groups, were made aware that there was a physical altercation between the two parents, literally over the child in question, the day before this was given?
That is correct.
You were not made aware?
That is correct.
And that's
And the
when-
way we were made aware is when the case manager, doing his job, did a 911 check. And when he did the 911 check, there it appeared. And the minute it appeared, he brought that to the attention of leadership. It was called into the hotline. An abuse report was generated. A child protective investigator commenced the next day and went in and began their investigation. The case plan was updated to reflect that fact and submitted to the court.
Why can't they
Understanding
go
that you
back?
have-
Why can't they go back to the courts and say, hey, we realize we just got this information, we need to go ahead and speak with either another magistrate, or we need to get this back in front of the judge and make a different decision? Like, how do you come across this information and now you have something else, you should be doing something else about it?
The child abuse investigator that was called immediately went out to the home and would assess risk. And that would have been what the judge would have asked about anyway. And so and we updated the case plan so that the judge would be notified with the updated case plan of the activity. But because there was an active investigation going on, we were waiting to see if the investigator would have assessed immediate danger and removed the child or not.
How do your organizations speak to the police? So when they go out and respond to that incident, how are they able to identify that that family is subject to a current case management program with either of your organizations? Can they even see that?
Absolutely.
And how does that work?
Because all of our information's in the same database, and so they've got access to that statewide database, and they can see that it's active. They made a call to our case manager upon initiating the case, and they discussed the case. The investigator went out and did their investigation.
So we understand.
I believe that we've misunderstood your question.
Yeah.
Because, can you restate your question,
Yeah,
please?
so that's my question is, so they go out on July 15th, and they're dealing with Jordan Belliveau
Oh, I see.
and
Okay.
Charisse Stinson. When the police are running those names, is there anything where your agencies talk to their systems where they can identify that this is currently subject to an active child protective
I did
case
misunderstand.
management program?
What would trigger that communication is for the law enforcement agency to call it into the abuse hotline. And that is what would trigger that communication. So no, there is not a system in which that law enforcement officer would know that without having first called the hotline.
So when you are in court before, and there are it sounds like about 4 conditions to be met for reunification at that point, where in the system does anything exist for subjectivity of your case manager to say, yes, these conditions may be met, but no, I don't think she's ready to get it back? Or is it as soon as those 4 conditions are objectively met that you have to, at that point, support reunification?
You know, I would say that it's probably somewhere in between. There certainly is professional opinion that is provided to the court. There are many tasks, that conditions of return often are point in time, as we can see even in this instance, which is that on this date, we've had housing for a period of 4 or 5 months. On this date, we've had we've had employment and the proof of employment for these many months. But there is some level of professional, subjectivity, if you will, to those conditions.
What would you say? I understand that this is a monumental task that you guys are undergoing, caring for foster children. 3,000 in our county alone that you do, us in Pinellas and Pasco County. When you look at this situation, what mistakes do you see were made in dealing with Jordan Belliveau? Because ultimately we have a dead child here.
Well, the first thing I want to say is that Ms. Stinson is the one who murdered her child. I don't believe I can speak any further because I'm waiting for the independent review that is currently underway. And once that review has been completed, I believe we will be able to identify and be able to answer that question.
But anything on just looking at it, did you say, let's try this better, or let's do something better? We can always improve. Anything we do can be done better.
I absolutely agree that we can always improve, and it is my absolute commitment that we will remember Jordan, and we will improve our system to the extent necessary to protect and serve our children, period, the end. But what I can say is that everything that I have reviewed could not have predicted that this mother would murder her child.
Wasn't your agency under an obligation to inform the court that this woman was not living up to the requirements of that court order in a number of ways, not just housing, but other ways as well? Not cooperating with your own people?
We fulfilled that obligation.
You informed the court?
Yes.
When did you inform the court? There's no reflection of that I've seen in the records.
We were in court on multiple occasions, and we provided to the court, again, absent some of the things that we've already discussed here today, which is that we did not inform the court of the domestic violence incident simply because we did not know that that domestic violence incident had occurred. Outside of that, we were in communication with the court throughout the process.
Well, let me just be really clear and specific here. Are you saying that you informed the court that this woman was failing to cooperate with you, that she was months behind in her rent, that she was jobless, that there had been domestic violence, that there had been a bullhorn incident?
So, Mark, I don't think that the last string of events there, that the court was specifically informed of those events. When we called in the abuse report regarding the incident in July, the domestic violence incident that we found through the 911 check, when we called that in, we also updated the case plan, which is submitted to the court as a piece of a document. Doesn't mean the judge saw it or the magistrate saw it right away. And we were, so that's that. I don't think we've did anything before the last court hearing, and I think you guys have gotten the documents on that.
All of those incidents that happened in August, you didn't inform the court of any of that? The failure to allow the guardian ad litem to see the child, the calling in police with a bullhorn in order for the CPI people to get there, the failure to pay rent, the eviction notice, the pregnancy, you didn't inform the court of any of that?
I can't speak directly to that right this minute. We will wait for the independent review to come out. I will say that every child welfare professional involved in this case had the opportunity to inform the court. So the guardian ad litem had the opportunity to inform the court if they weren't getting compliance. Everybody had the opportunity to inform the court. We were following the legal and judicial process as it currently stands.
The guardian ad litem informed you and other people in a letter on August 24th of noncompliance. Mm-hmm. Why didn't you take action at that point?
We believe we were taking action on that point. The case manager, in fact, had visited with the mother just days before that, and then again on the 31st.
On the 31st, the case manager told the mother everything is going to be okay. How is that taking action?
Well, that's 4 words of what was said during an hour-and-a-half visit. Taking action was talking with mother about the things that Ms. Stinson was identifying as her concerns, and developing a plan to address each of those concerns, up to and including, addressing the rent situation and/or the housing situation, the phone situation, those kinds of things.
And in fairness to you, just one more question. You started off by saying that no one could have predicted the behavior of the mother. I think there are a lot of people out there saying, knowing what we know now about all the things that your agency knew about and other agencies knew about, there were a lot of reasons to predict the behavior of the mother. How could you ignore those reasons?
I don't believe we did.
Yeah.
And the question of what is the goal here, there seems to be a conflict between reunification. We spoke with one of your former caseworkers the other day. Your own employee, former employee, tells us that quotas and reunification and numbers are the goal, that there's a tremendous push in your agency to keep families together no matter what. What happens to the paramount interest of protecting that child when that's a conflict with keeping that family together?
I want to say that the terminology of quotas has never been spoken in our industry, not from Directions for Living and not from any other member of our system of care has ever used the language quota, to be clear. And yes, there is legal precedent and statutes that require the reunification, the safe and timely reunification of children. That is the laws that we currently operate under.
And that's what the magistrate had to deal with, is what is the legal grounds for continuing to keep a child from their parents, and also whether the legal grounds for termination of parental rights. We do a lot of children that do not get returned. We do termination of parental rights. Those things happen all the time, but this has to have legal grounds.
And just to put a point on this, did your caseworker act correctly and appropriately on the 31st, the night before this child's murder, when he did what he did and did not remove the child or take actions to remove the child?
I am going to wait until we have the findings from the independent review before I answer that question.
What is the process of having a child removed from, does the caseworker have the authority, or does it go through a court system? How does that happen? I mean, what are the layers involved in having a child removed from?
Thank you for asking that question. The case manager does not have the authority to remove a child. The only person in our system of care that has the authority to remove a child is a child protective investigator
Or local law
or
enforcement.
local law enforcement.
How quickly can that be done from the moment of the initial, in other words, if that caseworker hypothetically said, tonight, they've got to go, how quickly can a child be removed?
Immediately. The child abuse investigator, as well as the law enforcement, can remove without a court order. For our staff, we would call them, and we would wait with that child. If it was urgent, we would wait with that child until they got there and made the move. We have people on call all the time, are very responsive to this, and that would have occurred.
Do you feel as if you should have that authority? Your people should have the authority to be able to remove a child if they see immediately, this child must be gotten out of this situation right this moment? Do you think they should have that authority eventually?
That's been a question in our business for some time, and it's always come back to, it's better to have independent eyes on that to make sure that it's a good decision being made. It could go either way with somebody that knows the family, has been working with the family. They could be more lenient or less. And so it's always been the fact to have independent eyes. That's one of the reasons why in community-based care we separated investigations from services. So the investigation is done independently. In this community, it's done by the local law enforcement agency. They have the ability to be independent, make their own decisions. They're not worried about services or no services. They make their own calls on that, and we think that's the best way to approach this.
We've talked about notifying on the August incidents, notifying the court. What would be the mechanism by which that would happen? If you had opted to notify the courts, how would you have done so typically?
The case management organization could go to our Child Welfare Legal Services, which is with the state attorney's office, and ask for a court hearing and a petition to reconsider.
Okay, and so one other question we have is there's indications that the family, due to noncompliance, was taken out of the reunification program that Directions was running. What exactly does that indicate, and what does that mean? Does that mean that they didn't complete their reunification plan?
What it means is that there were 13 separate counseling and or home visit sessions that could have been completed. Mother, Ms. Stinson, completed, I believe, 7 of those. And in post-reunification. So I do not believe that it is a fair characterization to say that she was non-compliant. I believe that it is.
I mean, that's in the records.
That you are correct.
Yeah.
It is in the record.
That's not my word.
You're correct.
So
what does that,
what does that mean?
It was one of her ongoing, so one of her conditions of return was to complete counseling. There was some question as to whether or not she had had enough. She had done counseling. The question was, had she had enough counseling? And the case manager in this case then recommended a reunification team to go into that home. And so the reunification team went in and was providing services. So for the reunification team to close out really doesn't trigger anything. It would not be in and of itself, would not be a reason for alarm necessarily, or a reason for removal.
At any point during the court process, can you just say whether there was ever an objection put on the record that went beyond whether she had completed counseling? Because we keep hearing about, and we do see that in the documents, it's clearly there. But was there ever, during any of the hearings that were involving the mother and the father, because there were several of these hearings. At any point, was there an objection that either of your groups put in that went beyond she hadn't completed counseling? A single one?
Not to my knowledge. I believe that, again, if that exists, that will come out in the independent review. But my answer to you today is no, not to my knowledge.
Ms. Lott, on that Friday night, your own case manager wrote in his case notes in the following days of that night, inform to both parents these things need to be fixed like ASAP or else the child will be removed. So why didn't he remove the child right then and there?
Our case manager does not have the legal authority to remove a child.
Why didn't he make a phone call to the people who could remove the child?
He believed, based on his assessment and his relationship with Ms. Stinson, that they had talked through the barriers and the concerns and that he had put a plan in place with her to address those concerns. And I might add that the concerns were not that he in any way, shape, or form believed that she would harm, let alone kill that child.
Was that a good decision?
How many interactions did the caseworker have with the family once they were reunited?
Once they were reunited,
Was that a good decision?
I believe that there were 8 or 9, I believe, that's off the top of my head, that there were 8 or 9 visits by the case manager and or the reunification support staff that was in the home post-reunification.
Did anyone ever prove or have evidence that Jordan Sr. was no longer involved in gang activity?
I don't know the answer to that question. Was there any proof that he was no longer involved in gang activity?
Did anyone ever ask him? I mean, did anyone?
Yeah,
was there any investigation done?
The records that the sheriff's office released indicated that that he denied being in a gang.
Right, but he denied it the whole way along.
Right, so he denied it. It is not our area of expertise to assess that. What we did know is that we needed to move that family from that location, and that we also knew at the end in August that mom and dad were not going to be living together.
I guess what I'm asking is why didn't anyone raise an objection in court and say, he's a documented gang member, why are we unifying with the child? You see what I'm going for here? I mean, in the paperwork, again and again, he's a known gang member. He's got guns around. There are drugs around. There are people around. There are gangsters around. Did anyone ever just find out whether he was still in that gang and then in court say he might still be in a gang if not?
There was no indication that he continued to be in a gang. Once that mother and child secured alternate housing, we have nothing to suggest or support that gang activity was around that child, continued to be in the life of that child or the mother. The child was not living with the father or in the home, the original home. I will say that, and it's not going to answer your question completely, but what I will say is that, when we look at this family kind of in isolation, it seems we have a lot of families that we are working with, 3,000 in fact, and many of them have these complexities related to their family dysfunction, and that was true in this case as well.
With that in mind, knowing that in mind, that you have these many cases, and that sadly there are more Jordan-type cases out there, these similar dynamics in family structure. Moving forward from here, what are you seeing that you can do now? Not waiting for reports and investigations to be completed, but right now today, since we have children out there right this moment that are in this limbo, what do you see as from this, what have you learned from this as far as moving forward and making it better and making it safer? Not safest as possible, 100%, because no one's safe, but safer for these children. So what are you learning from this now that you're moving?
So one of the things that we do in these situations is we will review all similar cases to see if there are any factors that we want to pay attention to, check to make sure that that these children are in safe environments. So every child that's in their own home that's under the age of 5, we're looking at their cases and making sure that they're okay at this point in time. We don't have any indication that there's any other case in danger. Again, we can't predict the activities of some of these individuals involved with these children, but we have done a review. We're doing an ongoing review of those cases.
Of course, the child not living with the father, but
are?
yet you guys have in the case notes that the child was about before this tragic accident happened, that the child was actually going to go live with the father and the paternal grandmother, who was also one of the residents in the house where everything started from. How was that keeping the child safe?
The father had been granted reunification, and we were preparing to do a home study in the event that the child might go live there, but the grandmother was in fact identified as a support system to the child and to both the mother and the father.
But at this point, you already knew that he had been arrested for domestic just in July, just a month, not even a month and a half earlier. How is that still even consideration due to the history stemming over 2 years of domestic violence?
We had added additional case plan tasks to the father's case plan, which would include batterers intervention, programming, and again, we believe that they were going to be working that case plan.
Getting back to the gang
Where's
activity,
Stinson's family in all of this? She has no one coming forward with Jordan, no one has come forward to ask about maybe being reunited with her maternal side of the family. Where's her family in all of this?
I do not, I don't know. I know that there's been some interviews with some of her family members, but I don't know the answer to that
Getting
question.
back to the gang activity, there was a family unification, there was a family reunification person who showed up to counsel the mother. She couldn't see the mother, and while she's waiting in the parking lot, 3 or 4 men walk up to the door and knock on the door. After that, another man walks up to the door. Wasn't that an indication of possible gang activity? Wasn't that a danger sign? What happened to that report?
No, I don't believe that that was a sign of gang activity. It certainly was not assessed to be a sign of gang activity. I believe the reference to that was to suggest that there were people who were knocking on the door and that mom apparently was not home, that it was not that she was not answering the door for the staff person and inside, but rather that she was not answering the door for anybody.
Going back to the reunification, I want to clear this, the reunification program with directions. That's something that the case manager identifies as important. The family should be continuing to go through, it sounds like, 13 sessions. The family fails to go through those 13 sessions. Is there no teeth to that? What is the point of that if there's no consequence for the family to actually have to do it?
We provide a lot of services to these families. We offer a lot of services to these families because of all kinds of reasons and the struggles that these families go through. Their ability to complete everything sometimes is inadequate, that they're not able to complete everything. And so the issue is, was it a concern? Absolutely. Was it an issue that would raise to the level of let's step in and remove this child now? Not necessarily.
Now, the mother was in foster care herself before she aged out of it, correct? Was it under your foster care? Who's the foster child?
Yes, to our knowledge, she was a former foster child.
Within your system?
I don't know the answer to that.
I don't know the answer to that.
I believe so. It was within the 3-county area.
3-county area.
Do you think that Jordan's death will lead to change? I mean, I know that there's so many of these cases that happen and the child ends up dead and then sometimes changes aren't made, but do you think that there will be changes this time? You know, there's been a lot of community outpouring and a lot of people wanting this change. What do you think?
I would think that in my experience over the last 35 years of being in child welfare, every one of these tragic events does generate some changes. They do. You don't always see exactly what happened, but there will be some changes that will be put into place to make sure that whatever we can identify as a weak spot or something that could be done differently, we'll put those changes in. They may not be big, grand changes, they might be small changes, or there could be big, grand changes. Those are yet to come to see what happens. But this is why the independent review is so important, for us to see and get an independent review of this case and help us identify what things can we do differently and better. Nobody wants this to be the end result here. Nobody thought could ever have predicted mom's behavior, but we also need to know what can we do to better protect these children.
What's the timetable of that investigation?
That's up to the Department of Children and Families. You'd have to ask them.
I mean, has it begun?
Yes, it started today.
It started today.
So
what is their, can you give me a sense of what they're doing? Are they interviewing people? What are they going through to, and what things are you offering to them that you have to offer to them?
We'll give them everything that they want, and what they certainly have the full record, and they've got access to all the information. But this is a special review by them, so we don't know if it will take 3 days or 3 months. It's really up to them to feel like they've completed the review adequately.
Is this like a CERT team, or is it different from that? Because I know this particular case didn't meet all the criteria for a CERT investigation.
Yeah, so
but is this like a CERT investigation?
It's not a CERT investigation. That's why they called it a special review. So I can't clarify any more than that.
Are the case manager and the case manager supervisor who worked on this specific case still actively working on cases?
Yes.
You both said time and again that no one could have predicted this woman's behavior, yet we know from her history, her entire life has been filled with violence. From being a juvenile until the last couple of years, she was wearing an ankle monitor last year because she violated a domestic violence injunction after committing violence herself. So how can you say that nobody could have predicted violence in this case when clearly she has a record of violence?
There was no indication, there was no allegation even that mom had acted in any way but nurturing and loving towards her son, towards Jordan. There was no allegation and or investigation even or for any abuse, child abuse towards her son Jordan.
Well, actually there was. There was a fight at Burger King that her boyfriend, the father of the child, was involved in. She jumps in the middle of the fight holding the child, and the child gets punched. How is that nurturing?
She attempted to, with her son in her hand, she attempted to pull the father out of that fight. That is correct.
How nurturing is that?
It was poor judgment for sure.
How would you characterize the quality of the foster parenting rendered in this case?
How would I categorize?
How would you characterize the quality of the foster parenting rendered in this case?
It was wonderful.
Mm-hmm.
It was it was wonderful, correct?
Right,
I mean,
absolutely.
I mean, people out there who may not be in the weeds the way we are with every detail of this case, they're seeing a beautiful family, wonderful foster parents, losing a child and having a child put back with a family that clearly, at best, was ill-equipped. How do you square that with the public who sees that detail on television every night?
Well, in this particular case, it becomes very difficult because of the end result, that mom murdered this child. But there are laws that protect the parents of children. And so, to the best of our ability, those laws have to be adhered to. And even though they're not perfect parents, even though they're not going to be, and I really don't want to sound like I'm defending this Ms. Stinson at all, but there are, the child-parent bond is something that is highly regarded in our society, and we don't take lightly the termination of parental rights or even the removal of children from their parents. And there's, we can't assure that children are going to grow up in, middle-class, wonderful homes.
Is there too much emphasis on reunification? Is it reunification at any cost?
It is not reunification at any cost, and that's...
In this case, though?
It was not reunification at any cost in this case.
Did the
What are you
system
folks gonna
fail
do?
Jordan? Did the system fail Jordan?
The system is under a lot of stress and has a lot of issues and we can always do better. The system did what, you're seeing what we did. We did everything that we were maybe not everything that we are supposed to do, but the system provided the services. There were wraparound services in this home. And we can look at the judgment calls that were made by a variety of people that saw this family together during the last month of their lives. But, so I don't know.
In December, Jordan's sister will be born. What's going to happen to her?
I think that's up to the Department of Corrections and how they handle those situations. I don't know.
In these situations, does that child fall under your authority again? I mean, what if you had any other similar cases where a mother accused of murdering her child is giving birth to another child, I surely wouldn't believe that child would have anything to do with that mother at this point after giving birth.
Yeah, that again. The way that child would come under our jurisdiction is through a court process and being removed and decided. Those are not our decisions.
Would you be petitioning to do that, or how? Kind of give me a sense of what might go on and what we could expect, because that's coming up. And what if you're in court petitioning to take the child, or if the court, or just who's all involved and what may happen?
That's not our role in this system. That's a role that is played by the child protective investigators. That's a role that's played by law enforcement, by the Department of Corrections. There are multiple possible outcomes for that child.
What could some of those be? We're thinking theoretically.
I mean, there could be a relative that steps forward and will take the child, or child could be put up for adoption. Those are decisions that will be made later on.
But you could be brought in on that, could you not, if possible? Because she'll still be in the county. She'll be under county authority.
Well, it depends on where she's located, that what agency might be brought into that. It doesn't mean that it will come back here to this county.
You mentioned the case manager was still working on the cases. Talk about the caseload for a case manager. Because, when we're reading through these documents, there are some glaring bits that stand out as things that possibly could have been missed. What is a caseload like for a case manager?
Currently, the vast majority of the case managers working at Directions for a Living are carrying a caseload of children of approximately 25. This particular case manager had a caseload of 24 children.
And is that in line with best practices? Where does that stand?
Best practices would be the smaller the caseload, the better, and certainly we wish that we could have our caseloads at about 1 to 17, 1 to 15. So certainly the caseload is higher than what I would call best practice.
Is it about 1 to every 24 right now for everybody, or just for that one manager? Or?
Oh, no, for the vast majority of them, and yes, I can only speak for my agency, but I believe that is true probably across the state.
You said you're looking at cases anyone of children 5 and under. Do you have a sense of how many cases those are?
I don't have that number off the top of my head, but it's a couple hundred at least.
Okay, a couple hundred. And then secondly, I'm sorry. We've seen, and I've done sort of where we've seen an outpouring of support of people now wanting to become foster parents in light of what has happened here. Can you give us a sense of seeing any increase or a substantial increase in the number of people who have come to your organization going, I want to help, I want to do something, either whether as a foster parent or as an adoptive parent or any kind of, I want to come help?
Not a single person has contacted my agency to say that they want to become a case manager or that they want to get involved. I have heard via social media that conversation is happening. I want to reiterate something that Chris said at the beginning of this conference, which is to say that we do need the entire community to join us in our efforts to support and protect the children of Pinellas and Pasco County. I welcome that. We need case managers every single day. We certainly need additional guardian ad litems, and we need volunteers and foster parents.
Anything you're doing or planning to do to generate that kind of volunteership, whether it be forums or anything that you're planning to do in light of this? There's a positive behind the negative, any negative. This is, I would assume, is one of those where you can try to generate some
We continue to advertise, and we will, there's a couple of community meetings that are going to take place that we'll be part of to encourage people to step up and get involved in the various methods that April just outlined. So we are always looking for that. We are always advertising for those kinds of volunteers and people to step forward. And I don't know how many people have contacted us to volunteer for foster parents. Every time we do a class, we have 20 or 30 families that start, but once that thins out after time, not completely. I mean, we license a lot of families every year, and a lot of families drop out because they adopt a child or they have to do other things in their life. So we're always in desperate need of foster families.
Everybody agrees we need more foster parents, but what would you say to Jordan Bellieveau's foster parents who have publicly stated that this case illustrates an absolute failure of the system?
What I would say to them is thank you for your, being such giving people and taking care of this baby as much as they did and how well they did, and that we would love to sit down and talk, and we've reached out to see if we can have a conversation with them about their ideas on how to improve the system.
What would you say?
And I would say that I am terribly sorry for the pain that they are experiencing as a result of the tragic death of Jordan.
So I have two questions. On August 24th, according to the records, a guardian coordinator indicated that they might reach out to police for a welfare check, given some of the signs of the family and the difficulty in reaching the mother. Did anybody at any point contact the police for a welfare check at the end of August?
I think that would be a question for the Guardian's office.
Yeah,
I am not
not
aware
them.
of that.
But neither of your offices did.
I'm not
No.
aware of that.
And I think if you look at the record, the Guardian did see that mother and child that day, on the 24th, later that night.
Okay. And, obviously in this situation, it's DCF that is the umbrella organization, but there's two organizations just on case management before us. There's the CPIs, which are the sheriff's office. There's a lot of contracting and subcontracting. So who is ultimately responsible in this case?
I think
We all are.
Yeah.
How do you rank among other organizations like yours? Either the same caseload or municipalities? Is there a ranking for, somebody, other organizations like yours in the state or in the country?
Let me make sure I'm understanding your question. Is it in relationship to the number of children that each case manager is serving? Is that your question?
Right, well, like you say, you got 3,000 kids you service, and I believe it's if I'm not mistaken. Is there a ranking that's like, some cities are ranked the proportion with their work with their load? Is there any ranking for you or how you're doing compared to other cities?
We have the second highest removal rate in the state of Florida.
Yeah, and the number of children that we're dealing with on a day-to-day basis is the second largest in the state. The first is Hillsborough.
Is there a national ranking, among like the city of Baltimore or municipalities similar size to this area that you?
No, there's not any kind of national comparison to numbers of kids or caseloads that we're aware of. That there are studies that have been done, for point in time, studies that have been done, but nothing that would compare on a regular basis. Our level of kids and caseload sizes and any of those things.
Did the law enforcement agency that responded to the domestic violence complaint on July 15th, did they make a mistake by not making an abuse hotline call?
Now, you gotta
I
ask them.
believe, I believe you would need to direct your question to that law enforcement agency, and I believe, again, that we are waiting for the independent review.
A lot of people are asking what the process is to notify a judge when incidents happen with the family before the child is given back to them. You kind of touched on it much earlier, but what is the process? Can you just walk us through what that is to notify a judge of alarming incidents with the family?
Well, it's to first notify the Assistant State Attorney, who is also, responsible and charged with working in partnership with the parties. So we would notify the Assistant State Attorney, assigned to the case. We could request a staffing that ultimately then would generate a document. I mean, there are probably, 3 or 4 avenues or mechanisms to get on the judge's calendar in order to bring an issue before the judge.
Do those happen quickly?
Yes, they can happen quickly. Again, it depends on the assessment of time sensitivity towards, for the issue at hand.
And the process is, if the child is in danger, we call the hotline. That's an immediate response. It happens right away, and a decision can be made to protect that child by that investigator. And then we would go to court. So if there's a issue that we want to bring to the court about compliance, regardless of what type of compliance, then we either ask to set a hearing for that particular issue and get it set as soon as we can, or we wait to the next hearing that's scheduled and bring it up then.
Are there too many agencies involved in this? It seems like we have, like you said, DCF and everything underneath. Are there too many hands in the cookie jar, however you want to describe it, involved with these cases and these children?
I think my answer to that would be, though, there's not enough agencies involved. There's so much work to do. There's so much need of these families. We need all hands on deck all the time. And it's extremely difficult and emotionally challenging to navigate these waters and make the right call every time. It's nearly, and so the more people that see these children, the more, especially if they're independent. So they're not, if we were all one agency, then you diminish the independence and the ability to raise the flags the way they should be. So we encourage more agencies to be involved. We want everybody to get engaged, and we think that it creates a safer environment for most children. And it's hard to, under these circumstances, it's easy to say that there was too many cooks in the kitchen and the right hand didn't know what the left hand was doing. But that doesn't change if there's if there's one agency.
I just want to go back to the idea of removal, just to really make sure that we're clear on this. Obviously, at the idea that once the 911 check is done, you guys make a call and it goes to the abuse hotline. At that point, the CPI is notified. There is evidence in the records that the CPI was in communication with both of your agencies as well as the guardians to get a sense of what was happening in this case, and that the CPI did, in fact, at the time of your reunification, personally have some questions about it. Your agencies are dealing with them every week. Would not at that point a recommendation to the CPI of, hey, yeah, there's something going here, trigger a possible removal hearing? And if so, why didn't that happen in this case? I know you're saying you guys don't have the power to remove, but you certainly have the power and the experience and the time with the family to make a suggestion that would encourage the CPI to act, who's seeking information from you guys. Why did that not happen in this case?
We cooperated and communicated fully with the CPI. Again, the CPI's role is to conduct an independent assessment and review, and that review was in process. It was actually in progress, and so we did communicate with the child protective investigator assigned.
But it was in progress for a month.
Yes.
So is it just not urgent? Was this not a case where that review was, sufficiently urgent to kind of hasten that process? Because a month is a long time for a kid to be in a dangerous situation.
But
that would be a question for this child protective investigators. Yeah. They do have up to 60 days to complete their investigation.
But if the CPI on day 3 had been given information from one of your case managers that they weren't completing the reunification program, that it was difficult for people to get them to answer their phones, the mom didn't have a working cell phone at different points, that it was difficult for them to answer the door. If all of that information had been communicated to the CPI, wouldn't that have made the case a little more urgent?
I want to be clear that all of that information was communicated to the CPI via the record. So the child protective investigator has access to 100% of things that are documented in that record.
All right, guys, we've gone just a minute past an hour, but I don't want to cut you off. If you have 2 more questions, we can take those, and then we'll have to wrap up. Everyone good?
Thank you very much.
Thank you.
Let's go one this way.
I want to go to you.